Welcome to the Liberty Mindset. Come and explore some of the ideas and issues facing our liberty. 2022 is an election year. As libertarians, we ask that you consider voting in the Liberty Mindset. Welcome, and thank you for your time.
All right, good day, everybody. Welcome back to Liberty Mindset, where we seek truth and we stay curious, openly discussing current topics and how they relate to liberty. Today, we are discussing the Sixth Amendment. And I'm here with sharp and quick-witted Gregor and our Oregon State Libertarian Gubernatorial candidate, Leon Noble. The Sixth Amendment has some very important factors pertaining to the justice system: the right to a speedy trial, the right to a jury, to face your accuser. These are pretty much the fundamental parts that people remember of the Sixth Amendment. But here's actually how it goes verbatim. In all criminal prosecutions, the accused shall enjoy the right to a speedy trial, speedy and public trial, by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witness against him, and to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. And right now we're seeing this last part, the assistance of counsel, the right to having a lawyer or a public defender, is kind of being blockaded here in Oregon, as we've seen. What do we think of the Sixth Amendment and how it's being utilized or vandalized now, Dave?
I love that term, vandalized. That's really good. In digging around, I found it interesting. Notice on the last line it says, and I'm not advocating for this, don't get me wrong, it's just something I learned, so I'm throwing it out there. Assistance of a counsel for his defense may, and to have the assistance of the counsel for his defense. And people nowadays read that as a right to an attorney. And it's not written as a right to an attorney, it just means you can have one.
That's true.
And what we now view as a right to attorney came from a Woodrow Wilson appointed justice from the, let me get into my right set of notes here, from a Powell versus Alabama in 1932. It was a capital case against a group of young people, teenagers a little later. They happened to have been of color, and they were accused of raping a Caucasian female. And Justice Sutherland, who was at the time Chief Justice of the Supreme Court, wrote that because of their lack of education and stuff, and the fact that they couldn't read, and he thought a lot of their troubles came from having bad counsel. And so in that case, he interpreted that the Sixth Amendment meant that the state had to provide an attorney if they could not provide one for themselves. So it's one of those things where the bench legislated something. Do I disagree that we shouldn't provide attorneys if somebody wants one? Given the complications of law now, well, number one, law shouldn't be that complicated. Number two, given the complications of law, no, I'm not against it. But as you pointed out, and here in Oregon especially, this year we have a specific way of having a public defender's office, and that public defender's office is overseen by a committee, and that committee was dismissed, summarily dismissed by our Chief Justice this year. And they started appointing new ones, but it's, throwing a bit of a hassle into their office. So you had more on that, didn't you, Jimmy?
In regards to the fact that we have multiple cases open right now and people are just kind of cycling through, being told they don't have anyone for them. I know it's just seeming like we're violating their right to a speedy trial. Yes, they could represent themselves, but most people don't really know the law or their rights well enough. What do you think, Leon?
I think that I think there's a lawyer that I've never met a lawyer that I couldn't beat because I actually read law when it pertains to what I'm doing, but most people aren't like me, and I understand that. The problem is that when the public goes to court, they're already overwhelmed, and the real problem is that there's a level of decorum and a specific way that you're expected to act in court. And a lot of people get frustrated or angry and they break that decorum. And as a result, the judge rules against them for it. So the number one problem is that there's this expectation that you're going to be extra, I'm going to call it extra civil while you're in court. And that makes it very, very difficult for a person to defend themselves. The upside is that if we're applying this directly, it's not just a lawyer that can defend you. You could have your buddy from across the street do that, or at least assist in your defense. You could have the entire neighborhood come and help you in your defense.
What would that look like in a trial? Would that be like they would be with you on like a lawyer would, or would they be witnesses that would call up to stand? How would that look?
Well, theoretically, it should be all of the above. And it also, if that's the case, because you're not allowed to tell counsel that they have to testify against their client. If you have 30 neighbors from your neighborhood as part of your legal team, they shouldn't have to be required to testify. So if it's an issue of something like, I don't know, your car blew up and they cited you for explosives, and you put your entire neighborhood on your legal team, and basically every witness to the so-called crime should be at that point covered under attorney-client privilege, because that's how it's written. It's not because the bar said so, it's because the law said so. So, and this is also the same reason why you can't compel a spouse to testify against someone. If they're mad at you, on the other hand, they're going to do it on their own. Just going to put that out there. So don't go saying, "Oh, well, you can't do that." And well, if they're mad at you, they can choose to do it, but they can't be compelled to do it. Basically, you know.
Yeah,
so
they're not going to be strong-armed to do it. Basically,
I'm seeing this problem, and I think that it's compounded by what's going on with all of our criminal cases, especially around Portland area. We've had a decrease in the amount of cases that have been able to go through. They keep the courtrooms empty. They don't allow people to sit in the galleries. So if it's supposed to be public, that means that the people are supposed to be hanging out too. For a while, they had suspended jury trials altogether and weren't doing any jury trials. So basically everything was on hold. Well, that's a violation of Sixth Amendment, because you have a right to a speedy trial. So they were doing it until they dealt with the COVID issues. That was part of the problem. And then another part of that, because they're still doing this, you walk into the courthouse, here in Lincoln County, if you walk in the courthouse, you're required to put on a mask. They're still requiring that here. So at that point, are you really able to have all of your rights? And I'm not convinced that you are. So theoretically, you could go and appeal this on if you get convicted of something, you should be able to appeal it and force the appellate court would be a change of venue anyway, but then go to another court and say, look, my right's been violated for these reasons. Public doesn't happen. Quick doesn't happen. Proper counsel can't happen. Why? Because all the lawyers are taking a couple of years off because they don't want to wear masks. So, there's a whole lot of stuff. I see things as systems. I see them as, the leg bone is connected to the thigh bone, type of thing. So one domino falls and the rest tend to join them. And that's one of the things that I don't think the courts are understanding right now. I think they're looking at themselves as this isolated organization. Now, that being said, and again, I think I've said this story before, this thought before. Portland, the district attorney in Portland is just declining to charge people. Mm-hmm. And I think that he's read the Constitution and he understands that he's going to have a hard time getting them through the system. Mm-hmm. But if he declines and he sets them out and he keeps collecting potential charges, so he goes from having, one or two to having this pile. And at that point, when they do get around to doing it, they hit it with the statute of limitations thing. The defense attorney is just going to say, you got to plead guilty because there's no way we can beat this.
So what is your basis for that conjecture?
The Multnomah County Court operating in 25% capacity. Mm-hmm. Means that they can't take as many. I mean, they still have to have civil stuff happening, but they can't take as many cases through, which means if you suddenly...
Talking about the DA specifically, though, you're including the courts, but you said the DA is not charging people and he's stacking these cases. My question is, what is your...
No, it's just a theory. It's just a theory based on the thought process.
His campaign promise was to not charge people for anything. It was part of what he promised to do before he got elected. It was part of his campaign. It has nothing to do with stacking up charges. He's just an idiot.
Well, like I said, it's a theory.
Yeah, and my point is, it has no purpose. But this is what he promised at his campaign. It's what they describe on the website because they're calling anything a victimless crime, and he's unwilling to charge any victimless crimes. And so he lets everybody go.
And that becomes a problem. So what he's saying is that property is a victimless crime, but it's not a victimless crime.
No,
somebody has to pay.
Do I agree with you? Yes. Do I agree with him in saying that property crimes are victimless? No. I think the owner of the property obviously is a victim, but they don't see it that way, and that is the basis. Not
only the owner of the property, but whoever's paying the bill for fixing it. The owner then ends up getting dropped by the insurance company. That's why a lot of businesses are leaving. They can't get insurance anymore to do that. Anyway,
it all rolls downhill and gets clumped together into this thing, and it's still it becomes a systemic thing. Now, it was a theory, and granted, my theory doesn't check out by his own admissions, and as a result, he's probably going to be challenged for his seat. It's either that or the citizens take their safety in hand and arm themselves and respond appropriately to protect themselves and their property,
which is legal in Oregon. To an extent,
it's legal.
Also, anybody who has defended themselves has faced charges because defending yourself apparently is not a victimless crime.
Well, then you're stuck in this system, this loop here that a lot of people are stuck in if you don't realize that you can defend yourself. Like actually in the court of law, like you can be your own.
Right. And
your own person.
Unless I find a lawyer who I know is willing to play games with me, I might lean that way. Let's look at Article 1, Section 10 of the Oregon Constitution, because it's related. No court shall be secret, but justice shall be administered openly, without purchase, completely, and without delay, and every man, sexist bastards, every man shall have remedy for due course of law for injury done to him in his person, property, and reputation. We need to change that, obviously, but
or we could just use the definition of man as
human.
As human.
That's not the woke culture right now. We can't do that. We have to say they, them, or they.
So what we need to do is change man to every human. Every animal
has man in it. And every Homo sapien shall have remedy due course for the law of perjury done to them in their person, property, or reputation. There we go. Is that politically correct?
Probably.
Maybe for a minute.
Well, I mean, we're three white Christians.
No, it's not, because I don't think 30 people are considering themselves Homo sapien.
There's definitely some people out there who don't think they're related to monkeys.
Right.
So,
and we can't say soul because some people don't believe in souls. I think that we should just leave it alone, because that's okay. That's a whole nother ball of wax. It'll never.
That stairwell was yawning, saying, "Come, enter me." Anyway, also a couple of interesting things.
I won't back that. I won't back that constitutional amendment just because it'll cause so many problems. Let's just leave it as mankind or humankind or the existence of thought. There we go. Let's use the Descartes method. I think therefore I am, and we could go there.
Well, I found an article on RomanoLawPC.com, Oregon Speedy Trial Rights, which I linked in our show notes, and I think I'll put it in our notes in the YouTube. But Oregon Revised Statute number 135763 requires that district's attorneys have a trial within 90 days. Now, that's been waived because of emergency procedures because of the COVID thing, okay? Oregon Statute 135746 indicates that a trial must be held within 3 years. Some of those are going to run into, and that there is no emergency caveat for that. That I know about, that I was able to find.
And that statute.
And ORS 135-748, this is my favorite one, because time spent diagnosing and reserving for fitness for trial is not counted in your time waiting for trial. So if you're deemed, or somebody says or claims or says mental illness, as long as they're being observed, doesn't count towards their 90 days. And finally, in Oregon 135760, inmates can request a trial, quote, forthwith. That's their designation of time, forthwith. Now, forthwith, according to the law dictionary, I did. Forthwith is an adverb and a term found in contracts, court orders, and statutes, meaning as soon as it can be reasonably done.
PRN. Okay.
So in other words, whenever we get to it is reasonable, whatever we consider reasonable, and what you're asking for is unreasonable, so we can't do it in that time. It does imply immediacy with no excuses for delay, but then there's the whole reasonable time caveat. And, I know that will, of course, be abused because of the current COVID restrictions the state is still putting forth on the state government and the state and most counties have mask mandates and have, assembly mandates and things that all the meetings nowadays are going video instead of in person, which I'm not against. I'm all over, being able to attend virtually. It works for me better. But on the other hand, it's also easier to shut people up in those meetings.
Right. I'm like, how does technology play into this now that we're looking at avenues like using Zoom or other platforms? I mean, you can stop somebody. You could have technical issues. You can just decide that, we don't want to hear this person anymore. Hit mute. There's a lot of control.
Well, that means that I can throw up a green screen and a fake thing to just take a picture from inside my house. I can go to Costa Rica where they don't have extradition, and they can say, "Don't leave the country," and I can go, "Yes, sir." And you're already gone. So when you got the order to not leave the country, you are literally saying you're not going to leave Costa Rica or whatever country.
Territory of the United States is not. Oh, that's Puerto Rico. Okay.
Costa Rica is not a territory.
I had Puerto Rico in my head, and for some reason, you're right. Costa Rica is a different country. My geography be good. So I'm sorry. I apologize for that, Space Cadet. I'm only on my first cup of coffee. I'm a little behind. So,
right.
So there are ways that can work for the person being charged, and there are also a lot of ways that can work against it. I don't know. I don't feel like the digital format runs risk of violating the being able to face your accuser, though.
Well, and that's, I think, is an important part. I know there's a lot of people that view virtual meetings as acceptable as a form of, they literally consider it the same as in person, but it is not.
Mm-hmm.
It's not. And it's not public either, because you can exclude somebody from that really easy.
Yep.
Yeah. I mean, it would make it nice and accessible for a lot of people who would not be able to go to the trial to be able to be a part of it. But it's still, that would mean that we would also need it to be both platforms in some ways to have make sure there's transparency, because the digital format kind of eliminates that.
Yeah. And, many state courts don't allow television cameras or any kind of cameras inside, which is fine as long as you let public into view.
Yeah.
I don't have a problem with not having cameras as long as you allow public witnesses. But as Leon pointed out, it's like, oh yeah, we can't have that. There's too much possibility of spreading COVID. So guess what? No guests, no observers, no gallery.
In the masks, I understand why a lot of people would rather not be in a courtroom, like with them, even the lawyers who don't want to have a mask on while they're presenting, not only because it's uncomfortable and it's annoying, but you lose so much of your ability to relay information that's not verbal to people when you take 2/3 of your face out of the equation. And you don't know how people are reacting. It's harder to read a room. You can read body language, but body language is only going to show you so much. And the body language, you can just sit there super stoic.
Yeah.
And not show any body language. You're just in a seat.
Yeah.
So it's harder to read what's going on and what direction you should go as a lawyer. But at the same time, now we're running into the blockade that Oregon's facing with people not being available. And thus Oregon, in wake of lack of public defenders, we ended up, Oregon Chief Justice ended up firing the panel because they couldn't figure it out.
Right. And they're still, they're still behind. And but therein lies the question of my question then is the only real solution for people to start defending themselves? I mean, I'm not against that. I don't believe that, if I can't figure out how to defend myself, then obviously the laws are too weirdly written.
I mean, there's no reason why we can't take the few public defenders that are around and have them do like a quick Zoom course of defending yourself 101 for the people who are really lost. I mean, that you could make a video of that for people to watch from recent public defenders and why things apply certain ways, just so people aren't completely blind going into it, because otherwise we run risk of a lot of people damning themselves.
So, yeah. That throws into another thing. Do you need a lawyer for a traffic ticket? Probably not.
No.
But do you know your rights enough to know that you need to insist on a jury trial when it goes to trial?
Yeah.
Those are things people don't know.
Yeah, people don't know. So as a result, what they do is they say something that pisses the judge off. The judge throws the book at them, and they end up having to pay the fine.
Well, the decorum aspect is definitely a big factor that people don't think about.
Do they also know that we have a thing called trial by affidavit? Doesn't require anything. It's literally you throw your testimony, you go get it notarized, you send it into the court, and then the judge decides what happened. I got pulled over in 2015. They never did come back with anything. I think they just quietly dismissed it after 3 years because nothing could be done. I think they were waiting for the cop to do something. And of course, the cop sees hundreds of people every day, so he can't actually remember what he did.
Right.
But I remember, and I spelled it out. He held me up for 45 minutes for a bunch of BS garbage that had nothing to do with me. And he just simply did not know what was going on because he didn't see what was going on. What he saw was somebody going 71 and a 55 and decided it was me. It wasn't me. So I couldn't go to Salem for it and filed a trial by affidavit. And sat and it sat. I called them a year later and said, well, we haven't, the judge hasn't decided yet. And I think what they were doing is just waiting for me to get pulled over again in Marion County by any cop so that they could stack on. And then that would prove that I was doing it consistently and they could hit me with both of them. But it never happened. I didn't get pulled over for another 5 years. So
and this trial by affidavit, I'll admit it's a phrase I've heard. I don't know enough about it. Like, does this apply to anything that you're tried for, or is it only smaller things like traffic tickets?
Well, I don't know if it applies to things. I would imagine that it would apply to anything that was maybe a misdemeanor. And it removes number one, you're waiving your right to trial jury by doing it. And number two, you're not going to be able to find your, what's the word I'm looking for? You're not going to be able to necessarily navigate your way through the system. And of course, you're literally attesting with a notarized piece of paper that this is true. So if perjury happens, you are so screwed. And if you say something wrong, you are so screwed because you've put it in writing and attested to its truth. So you have to be very careful with what you write. In my particular case, I made it about the fact that I was, number one, I'm a CDL driver. I am an expert in my field. I know the laws. I was not breaking any of the laws, but the cop was. And as a result, I put the cop's credibility in traction and left him there. Basically hospitalized for lack of credibility. So I had credibility and I just totally focused on my credibility being stronger than his. And as a result, I don't think he showed up because he had to write it down and he had to notarize and he had to send it in. So, and that's the, gets into the next part. You have the right to face your accuser. So if you have to wear a mask, is that really facing your accuser? If you're doing it over Zoom call, is that really facing your accuser? Putting your accuser in the same room gives this. Let's use social media for this. Putting your accuser in the same room versus doing it on Zoom is like having a Facebook argument versus having an argument on the street. The potential risk to you for screwing up somebody else's life is very, very heavy on your soul when you do that. When you apply a digital aspect, there's no weight of repercussion there. There's no thought of, am I doing what's really right or am I just being a jerk? There's none of that. So
a lot of people take that and run.
the potential for perjury then goes way up because now they can't get arrested for being caught because they're sitting in their home on a Zoom call or a phone call. So, and that's where things are at. So, and the reason I bring this up is because I was in the middle of a divorce during the COVID outbreak, and I was my own lawyer, and I was dealing with a lawyer who was incompetent. And when I say incompetent, I mean he literally was padding his pocket. He was padding the hours. Everything he was doing was in response to me already doing it. So he would file paperwork for visitation when we'd been doing visitation for 3 months, that kind of thing. And you're just sitting there going, what the heck is up with this guy? And I finally just said, we're in court. And I just said, well, no, we were on the phone. We're in court and we're on the phone at this point. And I said, look, this has gone on long enough. And this is ridiculous. Everything that this lawyer has done has already been enacted by me. So putting paperwork in after paperwork in after paperwork in is just slowing this down. This should have been done in February. We're now in September. This is the longest divorce I've ever been involved in, and it's purely because the lawyer won't get it through his head that it's time to move on.
Yeah.
I'm demanding the trial. And the judge goes, well, that's what it did. I'm demanding the trial. This needs to be over so that my child and I can move on, because clearly she has. We're hanging on to this, and it's causing irreparable harm to my child. And the judge goes, well, Mr. Lawyer, are you willing to get your client in here so that we can do this? And Lincoln County doesn't have mediators, so we couldn't go through the mediation process through a third-party mediator. We went through the mediation process with the judge, and the judge just kept, playing the neutral game and went back and forth, and we managed to work things out so that we could be done with it. It took all of an hour and a half tops, and understanding that the worst part about this is the lawyer didn't even bother. It's not about knowing the law. The lawyer didn't know the law. I had filed first. He had filed 3 weeks later. He insisted that his case was the one that was viable because it had been served. It wasn't viable because I filed first. In Oregon, whoever files first has rolled a Nat 20 initiative. I filed first. It goes to that court, and I'm the plaintiff at that point. So that's where the fun part gets. I beat him in 2 courts, mostly over the phone.
Yeah,
it's completely possible for you to beat a lawyer. I haven't met a lawyer I haven't been able to beat for the last 20 some odd years. But you have to learn how to read. That's all.
Yeah. Well, there is that, learning how to read, and
learning legal lingo, a little bit of that. It's a lot of it's jargon.
Well,
and I'm the type of person where it's like I start reading too much legal lingo.
Yes, that's exactly what happens when you're reading too much legal.
And then your brain just like, you start reading it and you're like, I need to do the dishes. Oh, look at the cat.
Right.
It doesn't interest everybody as passionately as it does others. And squirrel moments occur.
In every case, you have time. So you have a few moments to do it. You don't have to sit down and read it for 6 hours straight. You can read it for 5 or 10 minutes, kind of go, okay, I think I understand that. Let me think about that for a minute. Come back the next day, read it 5 or 10 minutes. Okay, I think I understand that. This is one of the reasons, though, why Oregon requires plain English language with the law. It's because you might be the one who's defending yourself. And if the law isn't clear, it's because too much legalese was thrown in there, and they didn't want that.
Yeah,
so
that's really cool.
Is it possible? I mean, there was this thing being thrown about that I'm 90% of it was of court is paperwork. Is it possible that a legal, a paralegal could be helpful? Sure. They were talking about licensing and insuring paralegals for the express purpose of helping people file the paperwork, and then they would go and appear for themselves.
It's an interesting way to do it.
You can do, what's it, LegalZoom?
Yeah, it's a site.
The problem with LegalZoom is that the templates are off. So you have to actually edit the template to match what the court does. But if you actually go to the court website, they will show you what it needs to look like. So it's not like you can't. It's not like you don't have opportunities to adjust what's going on so that everybody can participate at their own level.
So would one of your solutions for what's been going on with the lack of public defenders be encouraging people to learn or to defend themselves so that way they get through the system faster? Because it definitely puts more of the onus on the people who are being tried.
I think that if you my thought process is this: you need to simplify the system. Once the initial paperwork is done, you should be able to file a motion by clicking and putting the motion in. You should be able to do it online. Right now, you can do most of it online. You have to pay the fee, but there are forms that you can't file. Like if you're broke, there's a form that allows the judge to waive the fees. You can't file anything without that fee waiver. So you can't do that online. You have to pay the fee. That needs to change. You need to be able to say, okay, we're going to file this with this, and the judge can then say, okay, we're not going to continue until you pay the fee, or we're going to continue now and waive the fee, or we're going to set up a payment plan.
I find it fascinating that Oregon's Constitution says cannot be purchased, and yet everything has a fee.
Mm-hmm.
To me, there's got to be something wrong with that picture right there. I'm sorry.
Mm-hmm.
Yeah, that violates the rights of the poor.
Yeah, it does.
Yeah, well, and justice shall be administered openly and without purchase. To me, that means that it shouldn't cost you anything.
But they have this idea, well, we have to charge this because the courts require. Well, you don't have to. Once you file, like a divorce is like $400 ish, give or take. I can't remember. Once you file that fee, once you pay for that, it might be $300. Anyway, once you pay for that fee, you don't have to pay anymore. It's once. Mm-hmm. It's just to file it, and the idea is it pays for the clerks to do the work, the paperwork. Well, I've not been a clerk, but I'm wondering what paperwork is involved. Isn't it just putting it in the docket? I mean, that you're paying that person for calendar operations anyway. So I don't know.
Yeah, no, I understand where you're coming from, because we pay, we don't pay Oregon's the heaviest tax, but we're nowhere near the lightest taxed state. And where is all that money, if it's not going for our legal system, and it's not going for our roads, and it's not going for our justice system?
Then why are we paying?
Yeah, I mean,
what are we paying for? Why are we paying?
I mean, I know we talk about, this, all the road work and everything, but it's like, yeah, maybe I'm just spoiled because I'm from San Diego, who had generally excellent roads. But it seems to me, and I know it's harder here because there's actual weather, unlike San Diego, where it's, 75 to 85, 340 days a year, without rain, and I understand that that's a lot easier on a road than going from winter to summer. Like it is here, where it actually gets
that's a whole nother subject, but it's basically associated with the engineering. If you go with the standardized engineering, it's not enough. Even Alaska changes the engineering for their climate. Mm-hmm. So, but people don't understand this, and it's not given out. Very, very it's not a knowledgeable thing. So, but that's a whole other story. Taxation is still theft through extortion. So, this is, I'm looking at solutions, and the first solution that I would say is that instead of having, we have a bunch of classes in schools that are just worthless. Why do we need? I'm not even going to postulate how many people go out of the country, but why would we need to have every single high schooler have 2 or 3 years of foreign language? Why?
Well, that's a valid question. It's not that I don't support foreign languages, but I mean, if you don't have any interest.
I never had any interest, and I was in choir, so I ended up learning like 5 languages because we would go through each word, and we would learn how to translate the words so that we knew what we were singing about. You got
your Latin and your German and your Italian.
Yeah, and once you were, and as a result of that, because we sang Spanish and Portuguese and Italian, those are all very similar. Mm-hmm. So we would learn how to figure out which one was which, and we would learn. I was in a meeting with somebody, and they were speaking Spanish, and I knew enough Spanish to know that they needed a mechanic, and that maybe we could make some phone calls for him.
Yeah.
To see if we could find somebody who could help wrench on this guy's truck. But the person who was speaking to, I mean, he was there. One was a native Spanish speaker, one was a native Portuguese speaker who knew Spanish and English, and then there's me who doesn't know anything more than English and can kind of follow along because I can't speak anything, but I can follow along. I was driving a bus one day and some students in the back were bad mouthing this girl in Spanish, and they had no idea that half the bus understood them. Mm-hmm. They just assumed that nobody understood them. We all knew what they were talking about. And I said, look, I don't speak Spanish, but I understand a lot. You really should shut up. And then the girl, she actually got up and got in their face, and I about had to have the girl removed from the bus because she wouldn't let them get off the bus and was basically assaulting them, but they were being really rude. Yeah. And half the bus is going, yeah, you guys were totally in the wrong. So people know how to communicate in more than one language. And I've never had a Spanish class, but yet here I am understanding quite a bit of Spanish, and I can introduce myself in Spanish. Why? Because it interests me to get to that point. That's all it should take.
Yeah, and
we replace that with a legal, some basic rights, and not leftist legal. Like, let's actually hire a lawyer and put him in a school and in a classroom and teach these kids this is what your rights are according to the law. Well, it'd be better if it was a judge.
But you touch on that, but I think that's really part of the change in education that's happened since 1970. 1973, the Department of Education was created by our beloved Jimmy Carter. And
trash.
Yeah, well, no, I'm with you, but still, you notice that there was all kinds of standards that came down from that, and we stopped studying the Constitution. We stopped studying things of import to Americans. We got years of language. Huh?
Because I can vouch for that. I graduated in 2005. Economics was an option course. It wasn't required. Legal classes or anything that would teach you much in regards to legal aspects were not required. They were just, the bonus ones. And in American history just talks about the wars. That's it. You remember dates for a test and it's gone.
Yeah. Well, and I graduated in 1981, and one of the things we had to do is we had to have a trial in class. That was part of what we did. And I was a prosecuting attorney. Somebody was a defending attorney, and one of the students was a judge. And we all had to look up how to do our jobs, and we had to figure out how to charge crimes. And
ours was business. We had to run a company. That's what was our big thing. We had to run a company, create a new product, and sell it. That was what they taught us, as opposed to teaching us legally what our rights are and what we would do in said company if we were brought down for, plagiarism, stealing of an idea, which I think that would be much more interesting. But anyway.
Well, see, and we did that with some with like debate. We had some debate time, and that's what we discovered was that we didn't necessarily have to agree with what we were arguing with. We just had to be able to debate what we were arguing with, and it turns out that's the basis of our legal system. We have a lawyer who doesn't necessarily agree with it, but he's going to debate the points of it regardless. And he's going, and in order for him to do his job correctly, he has to provide competent counsel, which means that he has to debate it in a way that's actually competent. He can't just say, "Oh, I'm just going to fluff this." That violates somebody's rights. But if you truly believe, it's a lot easier. We were back in high school. We had a class called Contemporary World Affairs, and at the time there was this conversation about the federal speed limit going away. And they were like, and there were some believers in the speed limit, and I wasn't a believer. And somehow I managed to get on the side that said, let's just ditch the speed limit altogether. So I actually believed that the speed limit was stupid at the time because I never followed it anyway. And they were saying, well, it's going to cost lots of money. I said, no, it's not. It's not going to cost any money to just take the signs down. You're going to go and change the signs. That it will cost money because you're going to make new signs and you're going to pay somebody. If you just let the signs fall down and go pick them up as part of the trash, if you just leave them in place, because they at that site they said speed 65. Now they say speed limit 65. They just said speed 65. We had the basic speed rule. Why do you got to spend money on it? Just leave it. That's a suggested speed now. If somebody wants to go 85, get out of the left lane. It's as simple as it gets. And then change the law so that if somebody rear ends you on the freeway, it's your fault. So that everybody understands they need to be in the right lane instead of the left lane.
Well, I have a little trouble with being rear-ended and it being my fault if I'm rear-ended.
Well, that's how they do it on the Autobahn.
Yeah, but
if you're in the wrong lane and you get rear-ended, you are at fault on the Autobahn.
Any idiot that's driving that fast doesn't have enough control to not rear-end me. Therefore, it's not my fault. I'm sorry, but I will argue that to my grave because if I'm driving in a safe and sane manner and somebody runs up behind me, it is not my problem that they have to hit me.
If you pulled out in front of them,
but then it's not going to be my rear end. It's going to be my side of my car.
Well, no, it's still going to be a rear end because if they're traveling 200 miles an hour, you look in your mirror, you pull out in front of them, they don't have time. They don't have the time to stop or slow down. Yeah. And this is to alleviate the problems with traveling in this manner. On the Autobahn, that lane is the fast lane, and you work in it. You don't get to drive in it. You get to go from the middle lane to the outside lane. That's what you get to do. So, but that's a different discussion. This is a completely different discussion. But the point being is that we did learn how to debate things, and then of course we had a speech. In college, I had a speech class where the idea was that you would learn how to do a public address. Yes, some people can't do that. Those are the people who should hire lawyers or hire somebody or get somebody to help them. But making it so that the only people who can help you are members of the bar is kind of a violation of your rights. So you should be able to have somebody counsel you, but that doesn't necessarily mean that it should be somebody who is a member of the bar, who has a legal degree, who spent about 6 or 8 years trying to get to that point. It might not necessarily be that person, and it was never intended to be that person when these were written because the bar didn't exist then.
Mm-hmm. Well, and it does say assistance of counsel. It doesn't say assistance of a lawyer. Now, most people assume counsel means lawyer, but it doesn't necessarily.
Right. It's not synonymous.
And I consider that a usurpation of the word counsel. The lawyers have usurped the word and called themselves counselors often. But I mean, we just had New York State Rifle and Pistol Association v. Bruin come through a couple of months ago, and it basically said that the text and history is what mattered. So if you apply that text and history, that means any law that says you have to have a lawyer is unconstitutional and a violation of your rights, because text and history says you could counsel, not lawyer.
Yeah, well, there's a lot of exciting things going on because of that founding that is not necessarily even gun related. So you're absolutely right. So where are we going?
It'll change things.
So we've got our speedy trial. We touched on the fact that assistance of counsel is not a lawyer necessarily, or not just a lawyer. It could be a lawyer, but it's not completely limited to it. We touched a bit on being, seeing your accuser or being in person there, a little bit about our digital aspects of whether or not that actually fits, and the right to a jury. And then being informed to the nature and cause of the accusation. And we definitely touched base on a lot of this so far.
Cool.
do we have anything else that we want to weigh in on regarding that, or shall we?
Well, do we want to talk about the civil side of this, our Seventh Amendment?
Well, we've been going for 50 minutes. Do we want to start a new conversation?
I consider it the same conversation because what starts as a criminal case turns into unlawful detainer and false arrest and stuff like that. And now you have a civil case. So this is kind of the same concepts apply. You have the right to basically if the cost of it is over $20, you have the right to a jury trial. Mm-hmm. The caveat here is that it specifically in the Seventh Amendment says it only applies to federal, but most states have also enjoined the same concept in their own constitutions. So does it really an issue? Not really. But where do you get that it's only applicable to federal? It actually says it in there in the seventh. In suits at common law where the value of controversy shall exceed $20, the right of the trial by jury shall be preserved, and no fact tried by a jury shall be otherwise examined in any court of the United States than according to the rules of common law. So I don't see anything about federal there. I see. Maybe it was because I read it on something like Cornell Legal or something like that. Oh, and they're making the push because I know you got to be careful what legal sites you use.
Yeah, they say federal courts, civil courts off of Cornell.
Well, yeah, you can argue that a court of the United States is not a court of state of Oregon.
I mean, that's a good question because is it one of those umbrella situations where the court of the United States is any court that is within the realm of the United States, or is it this
amendment?
Yeah.
Yeah,
we're not going to get into it today.
We're not. No. But I mean,
that's what I'm saying is that it's arguable that you could do that, but our state and other states have already adopted things that preclude that. So it doesn't really matter because everybody agrees at this point. Just you have to use state law, state constitution versus U.S. Constitution. That's the difference. So it's understanding the rights are what you need to do. That means you need to go ahead and read your state and federal constitutions. And I'm speaking to everyone in the world here. You need to read your constitution because what it does is it defines what the government can and cannot do to you, not the other way around. It does not limit you, it limits government. And knowing what those rights are and understanding that those rights are, and I'm going to do this because I know there are not people who are religious. I'm going to do this in a way that it includes everybody. Mm-hmm. Rights are created by your existence at the time of your coming into being. So any law that tells you that your rights are forfeit is unconstitutional because the Constitution limits the government. Your rights are your rights regardless of where they came from, and they exist because you do. That's as simple as it gets. You need to know those rights. You need to study those rights, and you need to be able to be your own lawyer to keep those rights in play, because some lawyers are not motivated enough to keep you out of prison and will not necessarily fight for your rights. They will fight to keep your law, but they won't look at your rights. Here, I'm going to let me go let's deal with some of our measures that are in our ballot. Measure 114 adds a firearms purchase card. It's
requiring a class and
unconstitutional in its entirety. Magazine limits, unconstitutional in its entirety. Basically, the entire thing has all been deemed unconstitutional in the last 2 months. We put it into place, and it will cost us. It will cost us large amounts of money because somebody will decide to defend it when they should be going, we concede, and this, let's have a court order to repeal it. Mm-hmm. Senate Bill 554 put in a bunch of common sense things like how you can store your firearms and where you can go with that. Well, now they're all being challenged.
Good.
Every last one of them. Young versus Hawaii is a prime example. Young versus Hawaii basically said you can't carry outside your home, and we're gonna keep you that right.
Rifle and pistol, so it's very similar.
Yeah, it was very, very similar, but it was New York Rifle State, NYSERPA v. Bruin specifically dealt with the scheme of may issue and versus shall issue. So they determined that was constitutional, and then they went farther by saying, look, this is how you do this, and it's the same thought processes that were that they put in to DC v. Heller and stuff like that. So the thing is, if you have a law and there's no history and it defies the text of the Constitution, it's unconstitutional. We have that. In fact, our concealed carry laws, they're going to go under the scrutiny as well. Basically, what it says is that you cannot tell people they cannot carry a gun. You cannot tell people they cannot exercise their right to free speech. You cannot tell people that they can't have counsel with them. That's the limit. And maybe it's time that we made that limit stick. Maybe it's time that people said, nope, we're not going to do this anymore. You're wrong. You're going to fix this or you're going to get out. Mm-hmm. And at that point, now you're, because we do have elected judges, now you're voting against somebody. So be sure you know who your lawyers are, because your lawyers are the ones who you need to elect to be judges. Now, here's another thought that just popped in my head. Does that mean if we have a right to counsel, does it mean the judge has to have a legal degree?
That's a good question.
And most places do not have a requirement for that.
So my question really quick is why is the Seventh Amendment separate from the Sixth? Why isn't it all part of the same amendment? Is there a historical backing for that?
Well, I think, given my research, that the term common law has more to do with financial issues, like between businesses, between people, individuals, versus between the state and an individual. Where the Sixth Amendment applies to between a person and law enforcement, or a person and this local government. The Seventh Amendment applies to between individuals, and it's phrased that way very specifically. Or in common law, it's all about $20. Nowadays we look at that and laugh, but I mean that was a lot of money back in 1789.
That was a lot of money back then. I mean that's it's a lot. Yeah, it was a lot, and. This is just, and also it also is supposed to carry between, the reason it's in the federal Constitution is because it's supposed to carry between states. Right.
And, that's something that, people talk about states' rights, how important they are, and they are. But that's the thing about the Constitution, is that it goes all the way down to the city level. It applies all the way down to the city level, all the way from top to bottom. Mm-hmm. And I don't know if he's going to have to come back in or what. He obviously had some.
I'm still here. It's just my camera's freaking out.
Okay, you're here. You're here, audio, just not visual. Got it.
Yeah.
Okay. Anyway, so that's my view on it, because I thought about that way. What is that? What are the differences? And then common law is more about business law versus or personal damages, or traffic. It'll deal between two people with traffic accidents. It'll deal between two people, not between a person and then the state pressing charges for insert crime here.
Right.
Here's my theory about why they're separate. They are slightly different, and if they're separate, it's going to be easier to get them both approved. If they were together, it would have been very, very hard to get them ratified. Because things wouldn't nobody would be able to say, okay, well, if it's over $20, which means if the fine is under $20, then you don't have a trial by jury. Mm-hmm. So by separating the two, now they ratify them individually, and then the individual ratifications also mean that any amendments to those and their ratifications are adjusted, and you can't just repeal one. Go to say we're going to repeal this, and you end up repealing the whole thing in entirety, and therefore causing yourself problems. So I think the reason that they did that was specifically to address that. And yes, they're very similar. They have very similar thought processes, but I don't think that they did that I think they just wanted to avoid.
Yeah, I'm sure it was intentional to keep them separate. I just was one of those passing thoughts when we've gone over so much of this. Now I'm like, why are some of these separated when they seem like they don't necessarily need to be in the way the world works now? But actually, when you put it in that way, if you do want to change something, you want to amend the amendment, you can accidentally amend something out of a bigger chunk, whereas if they're smaller chunks, it's easier to go back to them as you need, and to get them even in place the first time around. Probably it took bite-sized pieces, which don't seem bite-sized nowadays.
Well, and they are all connected because a criminal case can turn into a civil case really quick now. Mm-hmm. But or a civil case can turn into a criminal case. That happens more often because you go and admit something that shouldn't have happened. It shouldn't have been admitted in court. Now you're being charged with it. So, and that's where the threat comes from. Is if you adjust one, you have inadvertently adjusted the other, and if they're separate, you don't have to have that risk. I think that's why they've done it that way, and that's why we should be doing a lot of things that way. That's why Oregon has a single subject rule. Is because if you have a single subject and you make a change to that single subject, it's not affecting any other subjects.
I'm sorry, what is a single subject rule?
In order to have a ballot initiative or a law, it has to apply to a specific subject, and it can be deemed unconstitutional if it does not.
Okay.
So you have to those laws have to be written in plain English, not legalese, and they have to follow a single subject guidelines, which means you can have one about gun control, but if you have, like IP Measure 114 has a lot of different stuff about gun control, so you could argue that it's unconstitutional because it doesn't deal with a single subject, theoretically. Versus we have an amendment that says you have to have proper storage of a gun, and defines what that is. That's a completely different subject matter altogether, but they won't necessarily be able to pass that because it doesn't go far enough for some people, or they won't be able to pass the other one because it goes too far for some people. I fully expect 114 to fail because of how many people own guns in this country, in this state, by the way.
Well, you have more experience here, so I'll acquiesce to you. But part of my challenge is that Portland is a different city than the rest of the Oregon. That's so obvious.
Portland's been driving gun sales in Oregon for the last 3 years.
Good. Well, then maybe there's hope because it is, owns only about a third of the population of the state, but they seem to drive everything.
That's where the people who do vote end up landing, but and a lot of people who really are passionate in their views land. Does not mean that the people who are passionate in vote land on the same side that us three are on.
And this is why it's important for people to get involved. Now this is where I I'm going to apologize in advance. This is where I say go to setoregonfree.com. Understand that this is a political action committee with the intent of changing our state for the better. Please go donate. We have no limitations. You just basically need to be inside the United States of America, and you can donate however much you want to Set Oregon Free. Please go do that today so that we can fight things like Measure 114 and pay for advertising for our candidates and have our candidates speak. Okay. I'm sorry.
That was
setoregonfree.com. setoregonfree.com.
And it'll be in the subject or in the
show notes
of this video. So
yeah.
Don't wait. Donate till it hurts. I'm sorry. I'm sorry. I'm not sorry.
Well, I think that definitely gives us some food for thought. We did a pretty good job at breaking apart our Sixth Amendment here and what it actually means. And probably one of the bigger takeaways I got from it was that the assistance of counsel does not mean lawyer. And I think that's an important thing that a lot of people in my age at least don't necessarily realize. So I thank you guys for teaching me today. Our next episode, we were going to really talk about a little more about the Seventh if there's more to broach on it, but otherwise we're going to look at the Eighth Amendment. I want to thank Gregor and Leon for being here, and then for all their knowledge, thoughts, and stories. And we wish everybody a wonderful day. Remember to seek truth and stay curious. And we'll see you next time on Liberty Mindset.